Thank you so much. Thank you to the audience for joining us today for this webinar. This episode is Handling the Arbitration. My name, as mentioned, is Jeff Zano. I'm your moderator for today. This webinar is part of the Financial Poise Alternative Dispute Resolution webinar series. Slide 8 provides a summary of the series, and slide 7 summarizes this episode. Speaking of the slides, you should understand that from the get-go, we're not going to really follow through on all the slides. We may not, we're not going to read these slides. This is a conversation. We want it to be like all the other Financial Poise webinars. Keep the PowerPoint handy, however, because I will try to indicate from time to time what slides our conversations are following. Slide 5 is our disclaimer. Please note that our PowerPoint is for informational purposes only. It should not be considered legal, financial, or other professional advice. So please note that. Okay, now it's my honor to introduce our esteemed panelists. We have Leslie Burkhoff of Mort, Hock, and Hamroth. Leslie is a partner with the firm where she serves as chair of the firm's dispute resolution practice group and is the former co-chair of the firm's creditors' rights and restructuring department. Okay, and she's also a member of our financial advisory committee at the AAA and has done a lot for the AAA ICDR. So thank you, Leslie. And then we also have Elizabeth Champnoy, Liz Champnoy. Liz is an attorney, consulting expert, independent full-time mediator, arbitrator, and trainer based in New York City with 25 years of experience in the field of alternative dispute resolution. Liz used to have my position at the AAA. And I also had the honor of seeing Liz over the weekend at a local pub in my area. Then we have Bjornsuk C. Snell and Wilmer of Denver, from Denver. Bjornsuk is a business litigator who represents individual clients in complex intellectual property and commercial matters, and his clients have sought his guidance in dispute related to failed business ventures and disputes among business partners, shareholders, and directors. Welcome, all of you. It's great to be here again with you guys. This is our 4th in this series. Okay, so again, my name is Jeff Zano. I'm Vice President of the Commercial Division at the American Arbitration Association, and I'm also an attorney. So feel free to read more about the panelists on slides 34 through 37. Okay, this webinar is a production of Financial Poise. To sign up for the great weekly newsletter that they have, go to financialpoise.com/subscribe/. Again, financialpoise.com/subscribe/. If you are attending the live premiere of this webinar today, you can submit questions using your web portal, and I will address those questions. If you are watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Again, info@financialpoise.com. Just include your question and the name of the webinar episodes, and we will do our best to get an answer to you. Okay, we'd also like to thank our sponsors today. Okay, and I'll turn to go to the sponsors. Okay, we have on slides 3 and 4, we have Mood Online Dispensary. Then we have Sunburst, maker of #1 typing app for education, and Max Asset, okay, restructuring and insolvency professionals. And we want to thank our sponsors again for being great sponsors. Okay, we're going to get started on handling the arbitration process. Okay, and I think I take slides 1 and 2, so I'll go to those. Okay, so what we're going to go over today is motion practice and hearing. That's #1. Then post-hearing submissions and award issued. Okay, so those are the 3 topics we're going to cover today with our panelists. And just be aware that there are specific rules and procedures for all of these areas. And at AAA ICDR, we have rules for all of these areas I'm going to mention right now: commercial, construction, labor and employment, and consumer. And then we also, in addition to these rules, we have regular track process, large complex case process, which is a case for American Arbitration Association. Anything over 3 million is considered large complex case. And then we have expedited and fast track. And then also we're really promoting documents only now. So that's something that we're really promoting at my company. I know the other ADR providers are also. So with that said, I will turn it over to Bjornsuk for information exchange and preparation.
Yeah, so for the hearing, by this point in the hearing process, the arbitration process, you will have instructions regarding how to get information and how to provide information. And it's for the attorneys on this conference, or this webinar, you're more than familiar with this, because this is analogous to a scheduling order, which defines when you can do discovery. So unlike litigation, what the arbitrator's goal is to do is to avoid the classic forms of document requests and all of that. So he or she will outline when exchange of information needs to occur so that you can use the information. This is kind of basic and hopefully it's really understandable, but from a war story standpoint, or from my anecdotal standpoint, I would really encourage all the parties and all attorneys to overproduce information because that allows you the most flexibility when trying to produce information to use as exhibits at the hearing. If you under disclose, you run the risk of losing the ability to to use it as a trial exhibit, because then you'd be accused of sandbagging the other side and all that. And no arbitrator wants that. Arbitrator wants to get to the truth of matters, just like a judge does. So I think if there's any similarities really that are consistent, an arbitrator is going to be like a judge and say, hey, that's unfair to the other side. You can't use that information. So unless there are exceptions to the rule, but the general rule is over exchange, over disclose. And if the other side's disclosing only portions of it, obviously you'll have most likely the opportunity. That's where pretrial motions come in to either object or to have the fight about what's relevant for the hearing if you need to. I recommend the latter part of it. That's really analogous to motions in limine in trial, and that's something you want to avoid because you're not talking about a juror who is not sophisticated. An arbitrator is very sophisticated, and like having a trial just to the court, that most motions to exclude stuff is not going to be ruled upon prior to a hearing. Might as well just go to the hearing and argue about it instantaneously or spontaneously when the issue arises, because then the issue may not arise because just because you disclose information doesn't mean you have to use it as an exhibit trial.
Yeah, so how long are your prelim hearings? Are they pretty extensive?
My preliminary hearings are pretty succinct. And so just to make sure I understand where we're using the same vocabulary, because jurisdictions are, use different vocabulary. My preliminary hearings are usually where you hash out all the procedural nitnoid and issues that are pending prior to the actual hearing, like a pretrial conference. So in my experience with arbitrations, just because the format's different and everyone understands that you're not going to have the same evidentiary rights that you're going to typically have in trial in the court, we rarely have large issues. So sometimes the issues, I think the only issue I could think of was the ability to call a witness remotely at a hearing, but that was the last time I addressed that was pre-pandemic. Now everybody's so comfortable with Zoom that that's not going to be an issue. So if your preliminary hearing is lasting more than half a day, I suspect your hearing is going to be continued, frankly.
Oh yeah, that's. I mean, the ones I see in New York are usually about an hour, maybe a little bit over an hour. And do you bring the client or not?
I allow the client to make that call. And here's my general discussion with the client. I always said, you're always welcome to participate in anything. Most clients don't come to these because they're inside baseball and it may go over your head, and I can easily explain afterwards. But frankly, at the end of the day, you may be wasting your fees because I'm explaining stuff that's not even relevant for the purposes of your hearing. So a client can always go to a hearing or a pre-hearing conference and observe and watch. And I have a few clients who do, but majority of my clients, I make that offer, but make it clear it's not mandatory. And most of my clients being business clients, they usually say, oh, I have more important things to do.
Yeah, no, the ones I see in New York, usually they don't attend, but during pandemic, they did. It was interesting because people were home. So I saw a lot more clients in the Zoom calls. Leslie, you're laughing. You saw the same thing. Is that correct?
Yeah, I'd say most of mine, we don't have clients on. I mean, they're always welcome to be there. We generally do not have the clients on. And I'm just going to, before I launch into this section, I just note that under certain of the rules and arbitrations, to Byung-Suk's point of producing everything, which I do not disagree with, you have also sometimes an affirmative responsibility. It comes up more in the consumer cases, if anything. You have to produce reliance documents. You are, in fact, more often than not, you don't actually have to serve a demand per se. Each party has to serve the documents they're going to rely upon to prove their claim, and then the demands go beyond that to other information. So, and I've had issues where people do not fully produce or mess up the production, and then we have to deal with it in a ruling. And other issues along those lines. And the only other thing I would say about a preliminary hearing, well, two different things. There's always the hearing that we talked about last time in our session about preparing for the arbitration and all of the deadlines. And then what I will usually do is at the close of discovery, before the parties are going to sort of gear up, maybe 4 to 6 weeks before the actual hearing itself, I'll have another conference call to try an issue spot. I'll cancel it if it's not necessary. I ask the parties to send me an agenda. What I'm hopeful is if they've completed discovery, they're getting ready to sit there and outline if they're giving me pre-hearing submissions, or at least their joint exhibit lists or whatever it is, they've started to identify issues. And so in that hearing, if I can, and they're really doing what they're supposed to do, may be able to cull out a few evidentiary concerns, avoid some additional quote unquote motion practice to keep costs down, to identify, do they need me to make a ruling on a document or a witness and how they're going to participate. And yeah, we have plenty of witnesses, appearing by Zoom. Usually it's experts or extraneous third-party witnesses, not key parties.
Sure. Well,
Okay.
Well, you're up, Leslie, on hearings.
Yep, absolutely. That's what I was going to get to. So you should think of the hearing really no differently, and with exception, to what you would be doing in any state or federal court, okay? It's very similar. However, a couple of things to keep in mind. The rules of evidence don't necessarily apply. And what I mean by that is, in court, judges are applying very strict interpretation of those rules. You're bound by what the rules are, and you'll deal with your objections and everything along those lines. Arbitration is just not the same. And what that means is, it's not that anything can happen and anything can come in. But as an arbitrator, whether I'm sitting by myself or with a panel of 2 others, I have greater ability to consider whether or not I want to allow something in that may be hearsay in the technical sense. And I can always determine what weight to give it. So not everything's going to come in, because there's still going to be things that they're not appropriate, they're not sustained, there's no foundation, but you're not going through the same steps you would if you were in a federal or state court, and I have greater flexibility. And my general rule is, if it's going to help me make a decision, or if it's something that I think I can, maybe I'm not sure about it, I can always let it in and then look at it later and go, this is meaningless, nobody ever spoke about it again, I can't tie it to anything, but I want to be educated. Also, while there are some judges that'll ask questions in certain courts, it is more likely in arbitration that you are going to get questions. We may ask them during an exam. I'm never going to steer a witness. I'm never going to interfere with counsel's doing, but if I don't understand something, I'm going to ask for clarification. I'm going to ask the witness, especially when you have experts in front of me, if I need to understand a concept and maybe the parties just didn't get it out of the expert, I'm going to ask those questions. I do, like other arbitrators, we are mindful of questions that, could be tipping a scale, or I'm not doing the lawyer's job for them, but I have to understand it. And I want to make sure that the hearing will continue within reason till everybody's gotten the evidence in before me. Next slide, Jeff.
The one thing I'd like to add to that is the attorney should really, again, always, refer back to the arbitration provisions constantly. And for the hearing, especially, just in case the arbitration provision has a provision such as occurred to me about 10 years ago, there was an arbitration provision that said the arbitration is going to proceed pursuant to the rules of evidence. Yeah. And so you're thinking, oh, this is more like a trial. And so we were able to make strategic decisions to our advantage given the rules of evidence. So just a reminder to all the litigants out there, or the less experienced attorneys out there, refer to the arbitration provision constantly.
And to be clear, what you're talking about, just so everyone, what about the provision in your actual agreement? So, that's right. For example, and something we didn't touch upon, but and we always get a survey at the end of the arbitrations, but you can put in your arbitration clauses rules on discovery. You can, too much is not a good thing, but some of this can be in there. And again, it's not like the rules of evidence are out the window. They're just not going to be as strictly adhered to. There's more flexibility. By the way, almost every arbitration order says, these are your deadlines, they're not getting moved without good cause shown. But of course, at times, with good reason, we will move it. I've moved hearings.
Yep.
It sometimes just becomes a logistical nightmare. But the idea is, I'm giving you a hearing and sometimes we're booking it 6 months out. You know, things happen, but don't treat it as cavalier. I'm locking up my calendar, everybody else is locking up their calendar. And if you really need to adjourn it, fine, on occasion, but you may end up waiting 3 more months for a hearing, especially if it's a long set of days that are outlined there.
Let me ask a group a question, the whole group. Have you been before judges, former judges in arbitration? And if so, do you deem them to feel like it's like a litigation as opposed to arbitration? Or have you had that issue? Have you been before a judge? Yeah.
So let me say that I don't emphasize, my practice doesn't emphasize construction litigation.
Yep.
Or employment litigation. So I want to add that caveat because I think the answer is different if you emphasize those kind of practices. I'm a commercial litigator, meaning a lot of business disputes. So, which requires a lot of interpretation of contracts,
Sure.
Which is dictated by the jurisdiction's precedent. So for the most part, I would say a good 90% of my arbitrations, and both sides have agreed to select former judges, mostly because we feel like, oh, as a judge, they have more experience on what's called interpretation and application and understand what's precedent, what should be influential or not. I will say my construction colleagues and my employment colleagues, they're very comfortable and they prefer, especially the construction guys, to use a arbitrator, regardless of whether they're former judges or not, but they're very comfortable using a experienced arbitrator or attorney, even who's never arbitrated cases, that has a fundamental understanding of construction litigation because there's nuance in there that is very specific to the construction practice. And I would say that employment attorneys, they're probably more 50-50, but the same thing. Sometimes there's employment doctrines that they think that judges know or employment attorneys know better. And so that's kind of what at least I go through in selecting what types of arbitrators that I want.
Sure. Liz, you have a...
Yeah, I was just going to add, there's been very few judges in my career that I felt were really good arbitrators. And you know, it's not a personal thing. It's just that I think it's a very different forum. While yes, there's overlap, there is an informality. There is I'm going to let it in, like Leslie was saying, because I can make the judgment, and more of a business sense in the arbitration process. And I find what I've heard from clients and what I've experienced myself is sometimes the judges are just too formal, make it too much like litigation, and they also don't consider sort of equity, if you will. You know, they're more focused on the letter of the law, the process, and so forth. So it's sometimes I've had a good experience with a former judge. Other times not. Sometimes there's a client, the client wants the decision from a judge because to them it has more gravitas or means something. So win or lose, it means something. But I think the benefit of arbitration is having an expert, right? Having a subject matter expert in the sense of somebody who does employment, construction, something specialized so that, you're getting the benefit of that expertise and not just, the legal mind of a judge.
Absolutely. Yep. Well, Leslie, before we go to you on postponement of the hearing, your thoughts on that?
So, I would agree that a lot of judges tend to be much more formal, and I appreciate Beyonce's, point about wanting someone who has more experience interpreting contracts, but sometimes you lose some of the benefits of arbitration, like Liz was saying, because it's so within the box. And you know what? The point is to get the information to make a decision. And think about sometimes as a litigator, you wish you could have gotten it in and it's really important. And now they're not considering it. So, where they keep it so tight, and quite frankly, there's always a concern, can it be more expensive? Because, whereas I'll take emails, so you hop on a call and make a determination on a discovery issue, they may want motion practice. And that just defeats and I'm being generalistic because there could be judges that view things differently. I want to be mindful of cost benefit analysis and getting to the heart of the matter, figuring out what it is, make a decision, get something done quickly to move the process along. So I think some of it's also just know your arbitrator.
Yeah, and I was just going to share an anecdote. It's not
Yeah.
worth much other than to say, every time I participate with mediation with a former judge, I typically ask them, hey, do you like doing mediation as opposed to arbitration, which is more similar to a bench
Yeah.
trial?
What do they say?
I would say, of course, this is my non-scientific result. Over 75% of them say they prefer mediation. They don't like the arbitration. And so that kind of feeds in, and they have varying reasons, but that kind of feeds into a little bit about both what you and Liz are saying.
Except I will tell you, in my experience, some judges are terrible mediators.
Yes.
Because for the following reason, I'm evaluative as a mediator in the right circumstance, and that a judge can be, but sometimes they're too directive. So they're more, this is how I would decide the matter, and that's the end of it. And that's not what mediation is. And again, I'm doing a very broad brush. The flip side is that I have something, and I've referred to it before in my presentations, called black robe syndrome, where the egos in the room are only going to take information from an existing or former black robe. It's as simple as that. And there's nothing I'm going to say with 25 years experience that's going to move the needle, where if I had a black robe on or had a black robe on at some point, they'd listen to me differently. So,
well, you know what, Leslie, when I do training of new arbitrators that are sometimes they're former judges there, I always tell them during the training, I say, listen, I will continue to call you Your Honor or Judge, but you're no longer a judge. You're an arbitrator. Get that into your mindset. So we try to really press that. I mean, make sure that our arbitrators at AAA that are judges realize that they're arbitrators, they're not judges any longer. So Leslie, going on to postponement of the hearing. Sorry.
Okay, so I talked about postponing already, so go to the next one.
Okay, yep, hold on.
So ex parte. So here's something to keep in mind, and believe it or not, this has happened. So, it happens in a couple of instances. Sometimes, a hearing has been scheduled and one side simply does not show up. That happens a lot in some of the consumer cases where, they've been served and they're looking for, the company may be out of business. But occasionally I have one now where I'm going to issue a ruling. I had 2 law firms show up, and I have in 2 separate matters. One law firm has simply not submitted the other set of papers despite repeated requests, and I set a deadline. So I can move forward on what I have before me. But the very important thing is this: if this is an out of the gate kind of default, in other words, a claim was filed with the basic pleadings and information, the other side didn't either show up for the preliminary hearing or hasn't submitted papers subsequent thereto, I'm not going to just decide this based upon the claim and default them the way you could if you file a complaint in state or federal court and there's no answer, everything's deemed true. The difference being is the other party is, I need before me the following: somebody with knowledge, having attested to whatever the key facts are and the key documents in front of me. You can then get your equivalent of a default judgment, but if all I have is a couple of, paragraphs of this is what we claim, and there's no evidentiary support, I can't do that. Now, bear in mind, if somebody doesn't show up, they'll have an opportunity. I'll go ahead and say you can either submit it on docs, you can submit it here, whatever it is. I just need evidence. It just can't be done on face value. The next slide.
Before you go,
okay.
Sorry, Leslie, I just had a
fine.
question for you. In your experience, when one party, just wanted to make it clear for the webinar participants, when one party is making it evident that they're not going to show up for the actual arbitration hearing, how are the costs split for the remainder of the proceedings?
Well, so here's the thing. It's very rare that I kind of know ahead of the time they're not showing up, other than I do my preliminary, first somebody's filed a claim, it's the first time and just nobody shows up, period. I don't automatically do a cost shifting. There are some areas where you can shift costs. So for example, where you have claimants, this comes up in the consumer case, I'm drawing a blank on the rule, but sometimes you have consumers that file what I call vexatious litigation claims against a more institutional. They put them through their paces, and then they don't pursue anything. They don't do anything with it. They've just, they're hoping money's going to come out is what's going to happen. I have the right to cost shift if I find that it was filed for the improper purpose.
Yeah.
Other than that, if somebody isn't going to show up for a hearing, in other words, they haven't given a responsive pleading, they haven't, I don't always, unless there's something embedded in the document or there's some other statute at play, I'm not cost shifting, because quite frankly, they're going to put their evidence before me. I'm not running them through a whole hearing. I mean, unless they literally want a hearing, I'll take it on docs and a declaration. So the amount of cost is it should not be that extensive. They'd have to make a real showing, or again, point to something in the contract. So for example, the other thing, next slide, Jeff, is, we have the ability to waive oral hearings. So there's, I think, three ways this really happens. One, at the get-go, at the first time I meet with everybody and we set a schedule, sometimes the parties know ahead of time. They're both in agreement. This can get decided on the documents. We're going to just do some discovery and have a briefing schedule. All good. We're waiving oral hearings. Second is, we'll get to the close of discovery, and the parties will have then had a better understanding, and then may say, you know what, we think we can do this essentially as if it was a dispositive motion. And I'll defer, and I would generally defer to the parties, but if there's something that I've seen to date that maybe makes me concerned, I'm not going to just allow them to do that, because if I don't think I'm going to get my answers, I'm not wasting time. And then of course, the last is, we get to a certain stage and one party has disappeared, there's going to be a request most likely to waive an oral hearing. The last thing I will say is, I sometimes bifurcate my orders. And so, for example, I won't even set, and I'll discuss this with the parties, sometimes we won't set a hearing because they just don't know what they want to do in terms of, and I'll say to them, I'm fine waiting till the end of discovery to set your hearings. Recognize that when we get there, you then have a trajectory out. You're not going to get a hearing 2 weeks, 3 weeks, 4 weeks after that. But if you think you may be more inclined to do things on the paper and you want to revisit it, or we're dealing with, liability and then damages, and maybe the damages needs a second round of discovery and a hearing, I try and be flexible. Everything should be geared to the case and the disputes at hand. It's not a one size fits all.
Okay, thank you, Leslie. Okay, actually, I have the next slide, and Liz, you might be able to jump in because you used to work for AAA also. Disclosures. Okay, this is very important. We say to our arbitrators all the time, disclose, disclose, disclose. Okay, as much as possible, whatever you can disclose, please do it, and do it initially at the beginning of the process. Also, the parties have an obligation to disclose under our rules, under AAA's rules. So this is very important. And who determines this? Who determines this? Well, we do at AAA. If it's a AAA case, we have an administrative review council that meets every Tuesday. It's 5 executives from the AAA and 1 former executive, and they meet and decide these disclosures, okay, and whether or not the person is going to stay on the case. So it used to be, when I first started at the AAA, and Liz, when you were at the AAA, we made that decision as the local vice president. We made the decision with consulting with legal. I think we have a great process now where it's determined by a body of 5 people, and if you go on our webpage, you can see the requirements for disclosures and requirements for removal of an arbitrator. So ad hoc, though, is awful. I mean, and I think all of you on this call have been part of ad hoc. If someone discloses something and one side has a problem with it and the other side doesn't, well, where do you go? You don't go to, you could go to the American Arbitration Association. We do have that service now, but in most cases, you end up back in court where you don't want to be. So disclosures is something very important. Objection to an arbitrator. Liz, any thoughts on this that you've seen in your career? Yeah.
No, you're right. Disclosure is very important. And I was actually talking to somebody yesterday about the ongoing disclosure process, that just because you disclose at the beginning, if something changes, you still have an obligation to disclose. So for instance, the person I was talking to yesterday said that one of the lawyers changed firms. My immediate question was, did you make a updated disclosure? And they were like, they hadn't even thought about it. So same for the arbitrator as well as for the parties. There's an ongoing obligation to disclose. It's not just at the outset. If something changes, new people come in, new witnesses, new firms, etc. The other thing I think it would be helpful, Jeff, if you talked about, because this comes up a lot, people want to they think maybe an arbitrator is biased, or they're upset with the conduct of an arbitrator. Can you
Sure.
talk a little bit about how that works? Like disclosure in our context, when I think about it, is like a conflict of interest, right?
Sure.
I
Yep.
know Leslie and I know each other. We're friendly. If I was going to serve as an arbitrator, I would probably say no, right? Because we're too friendly. It wouldn't work, right? However, some arbitrators wouldn't make the right decision, but they would just say, I'm no Leslie, we're friends, and let the parties decide, or the AAA. So that's like one where there's a conflict of interest, and maybe you shouldn't be serving because it would impact your neutrality. Arbitrators should be able to decide that on their own, but some don't, which is why we have the AAA to help people out and make the right decisions. But I think a lot of times clients, attorneys think differently about like a disclosure or objecting to an arbitrator, not in the conflict, but maybe the person just isn't doing the right thing, or the person doesn't seem to be listening or paying attention, or isn't responsive. How do you handle those?
Well, what we say is, definitely bring it to the case manager immediately if you have an issue, and then we will get on a call with both parties and discuss this issue. If they're saying that the arbitrator is falling asleep or not listening, so we have those conversations. Or the arbitrator, really doesn't understand. We thought this arbitrator knew this area of the law. He or she does not understand it right now. Is not following the rules. That kind of stuff. I've removed arbitrators based on those kind of things when both parties agree. It's sometimes challenging when only one side is saying that, because we don't know where that's coming from. Usually removal is based on conflicts, certain conflicts that they've had. But the good thing is now, and back to ad hoc for a second, the good thing is now AAA now offers that service to ad hoc clients to say, hey, listen, if you have an arbitration that's not being done by AAA or GMs or CPR, you can come to us and we will make the decision on whether or not that arbitrator should be removed. And we have certain standards online that you can look, and I think it's a good process. Much better, Liz, than what we had 10 years ago, 15 years ago at AAA. Definitely.
And one other question, does the Administrative Review Council, if I've got the name right, do
Yep,
they
it is
also
right.
handle objections based on conduct outside of the conflicts?
Yes, they do.
Okay.
They do. But
Gotcha.
usually arbitrators, unless both sides agree, unless the conduct is outrageous, and then we can have a decision on that. But usually it's just one side saying, we feel that the arbitrator is biased for a certain reason, nothing to do with conflicts. It's going to be hard to remove the arbitrator.
It's
And
sour
beyond something,
grapes.
Leslie, you guys see that too, don't you? It's
Yeah,
hard.
I mean, Jeff, you have knowledge of one case where, an objection, because they don't like the ruling. So,
Yeah, they don't like the ruling.
somebody got an adverse ruling and just, and the claim came up, they're biased. That's like saying a judge is biased against you because you lost a motion.
Yeah.
People lose things. So sometimes, the one or two times I've had anything confronted is where somebody just wasn't happy with it. Along those lines where it's come up, or, I'm aware of a case where somebody I know is taken over and is an arbitrator for something else, but usually it's that. And it's really important for those that are arbitrators out there. I mean, I am as fulsome as I can be in my disclosures. And sometimes I'll even go, for example, if someone from your firm hired me or looked to engage me, I would say, look, one of your partners and I speak on panels together and we're friends. If somebody thinks that's a conflict, I'd rather say it and know it ahead of time and be, as open as I can about it. And I would say more often, I've not yet, and I know a lot of lawyers, as do many of you, I've had plenty of cases with law firms where I know a partner or an associate, or they appear in some other stuff. Never had anybody say, oh, because Bob in Chicago, my partner in California, there's clearly an issue and you can't, she can't pick you as an arbitrator. As long as the other side sees it, so it's important. And the continuing disclosure is important too, to go back and, they add somebody or somebody's changed firms. And I get that from my case managers, they just added another attorney to whatever the case is. I'll run the name and I'll email back and say it's, I have no supplemental disclosures to make. Sometimes I do, but yeah.
And as you know, Leslie, we do like Amazon cases and these big companies, and a lot of times the arbitrators will disclose, I order from Amazon 5 times a month. So.
But I haven't gone that crazy, but I did have one with a bank And I have an account at that bank. I'm not a Rockefeller, so I made a disclosure. I bank at several financial institutions. This is one of my banking relationships. If somebody thinks that's going to matter, you know, in a major bank that has billions of dollars, my couple of shekels, but you know what? I'd rather say it than have somebody see me go to their ATM one day and go, see, she likes the bank.
Yeah, no. Again, we say at AAA, disclose, disclose, disclose. So with that said, we'll turn to Beyonce for settlement negotiations at hearing.
Yeah, for those webinar participants who have seen our earlier presentations, this is a common theme. You can settle at any phase of any dispute, including in litigation as well as in arbitration. So in the middle of it's not uncommon for in the middle of a hearing, especially hearings that last more than a few days, which unfortunately, or for my clients, I've had a few of those hearings where it last multiple weeks. We're still participating in settlement discussions. So unfortunately, sometimes my clients get a little too excited when there's settlement discussions, and they think that deal is going to be made, but it takes two to dance. And sometimes somebody approaches the dance floor, but they're not on the same page. And so we have to always participate in going forward. Those are practical realities. But to the extent you make material movement towards a settlement, I think parties and their attorneys should have a discussion about, hey, is it a good reason to mention this to the arbitrator for two purposes? One, to pause, to give us time to not waste money on legal fees and try to see if we can explore a settlement that resolved all the issues. Or two, explore introducing a mediator to try to bridge the gap. And here, in previous discussions with this panel, we've had discussions about whether or not arbitrator should serve as a mediator. And generally, the mediator should be an independent person, only because if the mediator is not successful and you guys have to restart the arbitration, you don't want any settlement discussions or representations or statements or behavior to reflect poorly on the rest of the arbitration proceedings. You want that to keep a secret. Once there's a settlement, it's easy enough to raise the issue with the arbitrator and say, Judge, sorry, you could tell where I spend most of my time, but you could inform the arbitrator, excuse us, we settled last night and we think we can stipulate to a dismissal of the arbitration hearing. It could be as easy as that and you're done. And otherwise, you can enter into consent awards. I don't see that often. And I'm not a huge fan of consent awards, only because that extends the relationship typically between the parties of the case who are in arbitration because they can't get along. But consent awards are much like consent decrees. They're settlements in the sense that everybody agrees going forward, this is how we'll behave. And it can define, if you mess up, what's going to happen. Well, just like any arbitration award, it's not public and it's not filed with the court. But if somebody breaches essentially the terms of that settlement that's memorialized in a consent award, it can be turned into the equivalent of a consent decree. I think most people who don't have litigation experience have heard that phrase when you hear about the police departments entering a consent decree about changing their behavior going forward towards treatment of their citizenry and all of that. So that's kind of analogous to that. But settle whenever you can.
Yeah, yes. No, quick question on the arbitrator serving as the mediator or med, that's becoming more popular. Have you seen that becoming more popular? I've seen it becoming more popular, and we don't like it at AAA. We're not a big, like you said, you articulated it perfectly, that it's not a good idea. But I'm seeing it more and more. Arbitrators want to do it, or mediators want to do it. What are your thoughts?
The reason it's not a good idea, if I may, is in mediation, and we've talked about this in our prior, right? And sure. I do mainly full-time mediation, as most of you know. The whole point of a mediation is that you can speak freely with the mediator. You can tell them in confidence, right? The good, the bad, the ugly, your real fears, your concerns, and so on. So if you're doing that with somebody who's going to make an ultimate decision, you're probably not going to share all the bad stuff, or you're probably not going to share your real concerns and be forthcoming. And
You're right.
so, one, you're not having a true mediation because you have an arbitrator who's going to ultimately decide and is still trying to help you settle it. That's not a good idea at all. And when I serve as a mediator, I will hear people say, okay, like, we can't get to a resolution. We want you just to tell us what to do, or basically issue a decision. And I still say, no, I really can't do that in good faith, because I know a lot more that's been shared with me than you would have shared in a hearing. So I don't know that I feel comfortable doing that. So I think it's just a bad idea. There's plenty of mediators, plenty of arbitrators. The
Sure.
true mediation process is to use that mediator to help you get there. But one point, and I know others want to comment, is because this is a practical application of what I see. A lot of parties in counsel don't listen to the arbitrator. And what I mean by that is the questions, like Leslie, you were talking about questions. And I tell my clients all the time, when the arbitrator is asking a question, listen very, very carefully and make sure you answer it. And make sure if there's a theme in the questions, right? Because I think really good arbitrators are going to give you signals to suggest certain things. By way of an example, coming up in the settlement context, somebody called me about a case a couple days ago, wanted some guidance, and they said, well, the arbitrator keeps suggesting that we settle. And I said, and you should listen to that arbitrator, and you should do your best to settle, because I think what the arbitrator is signaling to you is that this isn't a clear-cut case, and so, you should come up with it, or you're not going to like the decision nobody's going to like the decision. So listen, pay attention to what they're saying. I feel like people just don't do that as much with arbitrators. They just think you asked a question, okay, let me go on. And that's really key and important, is to listen to that arbitrator, watch the arbitrator's reactions and so forth, because it's really like a jury, right? In some ways.
It is.
I don't know.
So, and I'm
Great
going
point.
to add two things to that, because you're so on point, both of you. So first thing is, I'll take the most recent point last. I had a case where I quite frankly decided the entire case on the failure to answer a question. And let me be clear, it's not that I punished the side. It's not like, oh, you didn't answer my question. The inability to answer a question couldn't resolve the claim for me. I'm going, well, then somebody has to explain how this happened. You're telling me X, this is your predicate claim. This doesn't make sense. If that's what happened, how did this happen? And I asked the question and I got no answer. I got an I don't know kind of answer. And maybe they don't know. The problem was, this could not have happened if this was the claim. They just didn't make any sense. I couldn't resolve it. And in my decision, I basically said, I didn't get this question remained unanswered. Can only draw my own conclusion. And my conclusion does not, isn't in favor of the claimant, because I can't answer it otherwise. In terms of meet arb meet, you guys said everything that I would say. I think it is one thing to go from arbitration and go tell you what we want to mediate it. I would not have a problem with that, as long as we're not going back to arbitration. Once the wall comes down, the wall stays down, and that's fine. If you built a rapport with the people and they decide that they think they can get it done and they know you're a mediator, I see no issue with that. But I would be very clear, we're not going back to arbitration. Don't ask me. I don't believe in the converse. You can do it. You guys have explained why, Liz, you said it perfectly. And the only thing I would add to that is, I have had people say, well, what if everybody waives their right to complain about, trust me, the minute I rule against Beyonce, which I would never do, but assuming I did that, because he's just, always right, he's going to go, oh, she knew something. I told her, it's because I told her this, and now that's why she's ruling this way. I'm going to try and challenge it. And while we know those are limited, there's just no way to get somebody to waive something sufficient for me. So to me, if you're going to do it, it's got to go only one way.
But if you do it, no separate caucusing. You agree with that? So if you're doing a mediation and then you go to arbitration, hopefully there was no separate.
No, I will never mediate to arbitrate. I will only go the other way.
Got it. Yeah. No.
No, but I would never do it. I think it's a disaster. I don't understand why people think they can do it.
I will add that there's been one time I unsuccessfully pushed to mediate in the middle of an arbitration with the arbitrator. And I would say the considerations were that from my client's perspective and my perspective, we felt like the other attorney and other party were just doing horribly in the hearing, and we had a really good grasp of the issues where we felt like they didn't, and we felt like this arbitrator is going to probably be able to articulate the weaknesses of their case better because he's seen it. Now, that was unsuccessful. So to go to Leslie's and Elizabeth's points, I totally agree. But there are some considerations or some situations where I think people push with exception.
Yeah, and it's the party's process at the end of the day, but you guys made great points why it's not a good idea. So Beyonce, post-hearing submissions, you're up.
Yeah. Let's. I'll go through this quickly because it doesn't require that much discussion on it. Which is after the hearing's over, and to use the court or court proceedings as an analogy. That this is when the witnesses have testified, documents have been submitted, and all that stuff. Typically, the record's closed, and you can't add more things. Here, after hearing's over, the part of the presentation's over, an arbitrator can leave it open because there may be issues where the arbitrator could say, hey, I'm not going to just say there was no evidence presented on this, but I think I'd like Byung-Suk or Leslie or Liz to address certain issues, whether by briefing and or more evidence. And that's where it can be left over. It's kind of nice from my perspective as a commercial litigator, because when I'm doing trial, I'm always freaked out about, did I get everything I want into the record? Or did I make the record enough if I couldn't get whatever I wanted in to basically prep myself for an appeal? Here, it's a nice opportunity to either do briefs and or submit additional documents that explain things that you thought you presented well, but clearly based on the statements by the arbitrator, you didn't explain it well enough. And so you have another opportunity to do so. And then once it's closed, then the arbitrator, once the submissions are done, then typically the arbitrator issues a ruling within a certain amount of time. So I'm a big fan of it. And obviously that statement here, most parties typically file, within 30 days to allow for submissions post hearing. But just know that most arbitrators, depending on how complicated a case is, they're flexible. And also what's nice about arbitration is, hey, if the parties and or the attorneys involved have outside conflicts, I find arbitrators, unlike judges, are more willing to say, oh, you've got a month-long trial, you can't submit anything after that. Let's set the timeline that's really realistic for all the parties. At least in my experience, arbitrators have been kinder to me about my schedule than trial courts.
No, absolutely. I agree. They are much easier to deal with, without a doubt.
Right.
Okay, so declaring the hearings closed. This is me. Once the hearings are, I think it's me. Is this me or is this you?
Yep.
Beyonce?
Oh, it's you.
Oh, it's me. Okay. Once the hearings are closed, the arbitrator has a number of days with a regular commercial matter, construction, employment matter. It's 30 days unless the arbitrator asks for an additional time. For expedited, it's 14 days. Leslie, have you ever gone beyond that? Are you sticking to 30 days?
So the only time I've asked for an adjustment is on occasion the parties will have a schedule. The parties will then try and move their briefs because whatever's happening, their post-hearing briefs or things shift, or it's a document submission, and it may put me within my own conflict. I had something where I was on trial for the 2 weeks that they were going to get me their final papers, and they asked for an extension. So I said to them, look, I need more time. I can't do this while I'm on trial.
Sure.
So that's the and I'll do it with the party's consent and say, I can accommodate your request for an extension. You're going to just have to give me more time so that I can't deal with it right then. Or I have one where they scheduled arbitration hearings literally right 3 days before Christmas and said, I'll do that for you, but I'm out. We got to tack on. So it's usually that kind of thing. I've never had a problem. I've only had one instance where somebody fussed about it. And I literally was like, you've asked for 6 extensions and I'm telling you, you're hitting me up in 2 weeks of depositions. You aren't happy. I need another week. Then you don't get your, then I won't extend your time to put your papers in. Like you can't have it both ways. I mean, that's just silly.
It is. And the institutions are pretty serious about the deadlines and about the 30-day period, the 14-day period for expedite. We get reports on this. And Liz, you remember getting those reports, seeing what arbitrators are exceeding the 30 days. So we watch that. That's why another thing, we brought it up earlier about ad hoc, how ad hoc's bad. Sometimes I get phone calls, people saying, I have not received my award. It's been 100 days or whatever. And I go, well, give me the case number. And then they don't have a case number. I go, well, it's not a AAA case. So the institutions, all of them, are pretty serious about when the hearing's closed and when the award should be issued. Yeah. So now reopening of the hearings doesn't happen that often. It really does. I know, Leslie, you're shaking your head. Yeah, it doesn't.
I did it once because somebody raised something or submitted something in one of their submissions, post-hearing submissions. I thought we were closed. And then when I went to look at it, it looked like it was fine. And when I read it, there was like missing information. So I had to reopen it to say, you either get me the supplemental document or I can't handle this. You added something. And it was something that there wasn't an issue with them submitting it because the other side was just basically missing an action. But sure. I needed to answer the question and I couldn't figure it out until I got into it, that they hadn't really given me what they needed. So other than that, I've reopened a hearing once for like a week to get a supplemental, and that was it.
Yeah, I mean, I've been doing cases, I hate to admit it, since the 90s at AAA, and I don't see it that often. I'm less than 1%. Liz, Beyonce, what do you see this at all?
I've never moved to reopen a hearing, but I've experienced opposing parties doing that, and typically, and it's been rejected. Typically, it's because they base an argument to say, oh, new facts arose which are really relevant and material to the issues in this arbitration, and typically it's not. So
sure.
So I've never seen it reopen, but I would say if a party can argue, oh wow, we just learned about this, there's no way we could have reasonably learned about this prior to the hearing, and so let us reopen it and present it.
Sure. Liz, have you seen it or not?
No, never. I had one client once tell me case law changed and we want to give that to the arbitrator, and I said, well, it happened after the hearing, so it doesn't matter. Like, I don't see how
sure.
And it was denied.
Yeah, that wouldn't make sense.
I mean, bottom line, it happens, but it's rare. So it really is. Okay, Leslie, on to the award.
Oops.
Oh,
couldn't get the thing off mute. Okay, so here's, and I know we're getting shorter on time here. So a couple of things, super important. I really work, and most arbitrators do, to make sure I've covered all my claims, all my counterclaims, so to tick them off. One presented, by the way, really important. I had somebody who, they had their claim, my preliminary hearing order had a deadline to amend claims. When we got to our document submission, it was all on documents. And there was a request to address, et cetera, a bunch of things, including attorney's fees. And I looked back at the claim and said, yeah, you didn't ask for it. And you missed your deadline. I can't give it to you. It's nice that you then in discovery, and by the way, it was something that they, quite frankly, it was sloppy lawyering. But I had to say, the request for this and this is denied because it isn't in the initial claim. You don't go before a federal or state court and say, oh, by the way, I forgot that unjust enrichment stuff. I'm just going to shove it in my post-hearing briefs. If it isn't in your complaint, you don't get it. It's important. People, Liz would tell you too, pay too little attention to the claims that they file, and it's fine to get it started. Go back and deal with it and supplement it and be mindful. And quite frankly, if you think you need some discovery before you finish amending it, you need a little bit of sort of initial, then make that request. We've talked about the time period already, really important. I stay on top of that. There's different types of awards. Sometimes your underlying agreement will provide what kind of award is supposed to be given, but we cover this at the preliminary hearing stage and go over it. And quite frankly, if the parties' agreement says a full reasoned award and they both decide they don't want one, as long as both parties are in agreement, it is the parties' process. You can modify your contract up or down, whichever way you want to view it. But we go through that. And quite frankly, sometimes I've had people say we want a simple award, which is just basically you win, you lose with a little bit more. And they change their mind by the time we get to the hearing. So whatever's in my preliminary hearing order, again, if both parties after a conclusion of a hearing have made a different decision, if they're in agreement, that's okay. Brief reasoned gives you some of why I got to where I got to. Full reasoned, people usually want that when they're worried about confirming an award, whether it has other level of precedent, maybe it has impact on another case. But recognize that if you have a lot of detail in there, if you go to confirm the award or to enforce a judgment, that fully reasoned award is becoming part of a public record. And while arbitration, and we've covered this in early sessions, is not necessarily fully private, you are losing some of the benefits if you ask for more, because quite frankly, you're not going to control what I'm writing. So if you've asked for everything, I'm going to do what I can to lay out a foundational record with all the evidence. You don't know what's going to come in. I'm not saying don't do it, just do it with your eyes wide open. And I think I covered the other slide about the decisions.
Yep.
One, the rules. Oh, by the way, and sometimes the rules will cover it. But again, the parties can ask for something different than the rules provide. So a lot of like the consumer rules and things like that will say it's a basic award, but if the parties want to, and flip side is the parties have to pay for it. Some of these are fixed fees. So you can't ask for a fixed fee hearing and process and then say, I want a fully reasoned award. That has to take it out of there.
Thank you, Leslie. Okay, Beyonce, challenging appealing the award.
Yeah, I think this can be generally summed up in one sentence, which is challenging and appealing an award is difficult. So for the less experienced litigators, really be mindful of the disclosures or lack of disclosures by the arbitrator. And this is why Liz and Jeff appropriately said disclose, 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 because once disclosures are made, there's less opportunity to establish a reason to vacate, because most states have laws on the books that says here's circumstances in which we can vacate a judgment, and they're tied to either the arbitration award is a result of corruption or fraud or partiality or misconduct by the arbitrator. And so if there's no, typically that's where the disclosures come into play. Let's say Jeff is my arbitrator and I'm suing Microsoft and he happens to be a board of director, which obviously he would disclose, but if he didn't, then you can suggest that it is improper misconduct, because that's the broadest term you can say you can use, because fraud is difficult to prove, corruption is difficult to prove, and partiality is difficult to prove, but with lack of disclosure, that gives you an opportunity. The other ways that you can challenge, have a basis to challenge, is basically you can, an arbitrator exceeds their power, meaning if the arbitration provision is narrow on what an arbitrator can decide, and his or her award exceeds that narrow scope, then you can challenge it to say this is improper, there's no basis for it. And also, if there's no arbitration award, no arbitration provision, you can challenge it saying the whole arbitration was a waste of time, but you got to object to that from day one. And if you don't object to day one, you waived it. So that's the things to think about. Let me just jump right into enforcement, because this is the part that's tied mostly to standard litigation, which is once you get an arbitration award, you need to turn that. If the other side doesn't consent, roll over, and give to the extent they're obligated to make payment, they don't make payment. What you need to do is take that arbitration award, convert it into a judgment. And most jurisdictions have laws, including foreign jurisdictions, through the Hague Conventions, about how to convert or how to deal with arbitration awards. So this should not be unfamiliar in almost every jurisdiction. There are jurisdictions who aren't participants in the Hague Convention regarding arbitration awards, and that's easy to figure out. And I suspect most of us can name the usual culprits who don't participate in that kind of thing. But once you turn into a judgment, then you can start enforcing it, which is, you can start judgment collections efforts. And there are laws in place. This is where state laws come in place, such as state homestead laws, which says a citizen can not lose their home up to a certain value of home or something like that. And some states are more generous than others in homestead laws. So collectability on that judgment becomes difficult. There are fraudulent transfer laws which prevent judgment debtors, meaning if I lost arbitration award and it was converted to a judgment, then I'm a judgment debtor. If I can't hide assets to avoid a collections effort to do that. So, but ultimately, this is And the enforcement section should be considered at the very beginning of representation if you're the
Right.
initiating party, because if you think you're going to get a likelihood of a great judgment, but you don't think the opposing side has any assets to collect on, I would say to most parties, you should consider the cost benefit analysis of that.
Yeah, great. Well, thank you, Youngsuk. Liz, you're the closer.
So
You're
I
closing
was
us
gonna
out.
say,
Key takeaways.
I think we're out of time,
But-
so I'm not gonna go through all the slides. I think the key takeaways of all of our programs, really, if we're just focusing on the last two with arbitration, mediate where possible, settle where possible to save the time, to save the money. In arbitration, it's not supposed to be litigation. It should be quicker. It should be more efficient. To make it so, you really need a well-drafted arbitration clause. You really need a good arbitrator who not only has subject matter expertise as well as, case management expertise. And you really need an organization, like the AAA and there are others. So, but like the AAA that guides you through that process and oversees it, and not the ad hoc stuff we were talking about before, where you're basically dealing directly with the arbitrator on sensitive issues such as payment disclosure, et cetera. So that's how I would sum it up. You can make arbitration what you want it to be, but for it to be what it should be, coster, more efficient, getting a subject matter expert as a judge, you really have to have an advocate as well that knows arbitration and not just litigation. And as I mentioned, an arbitrator and a well-drafted clause. As
Great.
fast as I could go.
That was amazing, Liz.
Very good.
That's true. And I want to thank our audience. This concludes our webinar, and I want to thank Financial Poise for this entertaining and educational production. And please stay tuned for future ones. And I want to thank the panelists. You guys, as always, are terrific. Thank you, guys. I greatly appreciate it.
Our pleasure as
My
always.
pleasure.
Thank you.
Thank you.
Be well,
Bye-bye.
be safe. Thank you.
Bye.
Bye all.